Yes, Mr. Haynes.
May it please, my lady, and my lord, I, together with my own friend Miss Burley, appear on behalf of the appellants, who are two boys.
And shall we deal with some anonymity first?
Thank you.
There's no formal application for anonymity, but is it common ground that we should make an order under CPR 39.24 to the effect that the identity of any family member in this case should not be disclosed in this hearing on the basis that is necessary to protect the interests of the minor children?
Thank you, my lady.
Is there anybody from the press or any member of the public who wishes to make any representations about that order? No. Members of the bar, you're all happy with it?
Yes.
Thank you very much indeed. Yes.
So my appellants, my lady, my clients, the appellants, one of them is now 12, will be 13.
Almost 13.
In 2 years' time.
Yes.
And the younger child was 11, I think, last Sunday.
Yes.
My lady, this is an appeal against an order of the President of the Family Division made on the 22nd of July 2025 when he refused to set aside his own order for the summary return of both children to the United States pursuant to the 1980 Hague Convention concerning international child abduction. There is one single ground of appeal, simply that he was wrong not to set aside his own order. My lady, the background is quite detailed and complex. It is set out in the President's judgments and in our skeletons.
I think all of you have taken the time and trouble to set out a lot of the background, necessarily or perhaps as a result, a lot of overlap and repetition, but we have read all of the skeletons. And in fact, I think we're on top of the detail of much of the material in the supplemental bundle as well. Could I just inquire on behalf of the court at this stage, Mr. Hames, have you taken the view as to whether or not you're going to address set-aside first, and then everybody deals with set-aside and come back to what if on any redetermination separately, or are you going to do your submissions compositely?
I was in fact going to inquire of the court what would
Yes.
be most convenient.
Well, do you have a view?
Well, there is some degree of overlap, but logically we don't get as far as the submissions on rehearing until this court has made a decision on set-aside. For my part, if the court were with me on the ground of appeal, it's essentially binary in my submission. So if the President were wrong, then I'd rather assume that there wasn't much more to say that the return order would then be set aside. And that would be the logical position if there were to be a separation of issues for the court to hear from everybody on those issues before going on to hear any rehearing.
But if there's an overlap, will it be more efficient in terms of timing for you to make all your submissions on the hypothetical that you are right on the appeal, to have everything in one go from everybody?
I'm very happy to do that as well. For my part, I was prepared to do either.
All right. Are there any strong views from anybody else?
No strong
Mr.
views.
Gratian, Mr. Gupta, no?
No.
No. Well, I think, see how you go, but I think provisionally at this stage, do it all in one go.
Thank you, Melanie.
And then that'll work. Thank you.
Melanie, I'm very grateful for that, but I think it would be worth just setting the scene in respect of the appellant's position in the litigation generally and in respect of this appeal. As my lady will have read, the appellants both steadfastly object to returning to the United States and have made it abundantly clear to all the professionals they have spoken to, as well as lay people and as well as their friends, that they would refuse to return. At present, there have been no enforcement measures taken because actually the return order has never yet been capable of implementation for one reason or another.
Sorry, why is that?
Because the time for the time for the children to return has never actually been passed.
Right, I see. Yep. Yeah.
Lord Justice Moylan stayed.
Yes, he did. Yes, he did.
Of the, I think the 9th of August, and then obviously stayed pending this appeal. Maybe I should also observe that as far as the children's relationship with their father is concerned, they haven't seen him for 4 years. My lady will have read some of the reasons for that. but from the children's perspective, they are simply terrified of him. They do not want to have anything to do with him. They believe, rightly or wrongly, but strongly and consistently, that he has physically and sexually abused them and threatened to kill them if they were to tell anyone about that abuse. They are happy, secure and settled here in the United Kingdom, at home, at school and at their church, where they have lived for now over 3 years since they were wrongfully removed here by their mother in August 2022. They are having therapy here. They are seeing a counsellor. There is no evidence for the basis for how the therapist is operating. The President, in the initial proceedings, in his first judgment, accepted that a return to the United States would be traumatic, stressing and upsetting. Very worryingly, my lady, both children have expressed suicidal ideation at the prospect of a return. Sadly, it's their position that they feel that the courts are not really listening to them. Malene, I accept none of those matters are directly...
Well, nobody's writing anything down at the moment, Mr. Hames.
I see.
It's important that you set the scene, and we understand that. But it doesn't help us on issue 1, does it?
I entirely accept that. And I also accept not only is it not directly relevant to the ground of appeal, but it's now going to be almost forensically impossible for the court to make any findings about what the children believe. I can only point out, as Lord Justice Peter Jackson has done in his judgment in Riyadh, that under Article 13b, the court is not so much concerned with finding fact, but assessing risk. And that's where the children's views and beliefs become far more important. So I emphasise that the correctness of the decision of the President to return the appellants to the United States is not the immediate issue raised by this appeal at all. The issue is simply whether he was wrong not to set aside his own order. Just dealing very briefly, if I may and if I need to, with the legal test.
I think yes. I don't think it's controversial, and it's well established.
It's in the rules, Rule 12.52a, practice direction, and comes from Lord Justice Moylan, initially in Re W, before the rules were changed, and then also in Re B.
Is it Re W that prompted the rule change?
Yes. Well, there are a series of decisions in the Court of Appeal. I think Lady Justice Black at one stage didn't have to address the issue, but thought it would be preferable if there was a rule, and therefore
Right,
the rule
but
was
by the
changed.
time we get to B, the rules have caught up with the authorities.
Yes, but the test adopted by the practice direction was formulated by Lord Justice Moylan in Re W, crafted from other decisions of this court before that. My lady, the only other legal issue directly relevant to the first issue, which is the set-aside, is perhaps to look at the latest word from the Court of Appeal about protective measures, which is set out in, I think, the newest member of the Court of Appeal from the Family Division in the judgment of Mr. Justice Cobb, as he then was in Re T. And while sitting in the Court of Appeal before his eventual elevation, he set out with in some detail, with great authority, collecting all the wisdom from this court as to the appropriate law to be applied when considering protective measures.
And so
I can take my lady to
198 of these authorities bundle.
Yes, thank you. And hard copy page, I can take my lady straight to 214.
Thank you.
Which is, I'm not going to deal with introducing the facts of the case, so I'm only mining this authority for the principles on protective measures. And it really starts at paragraph 45, some pretty generalised but important points about protective measures, the importance of the court identifying early in the proceedings. Particular importance for this issue is subparagraph 4 of paragraph 45, the status of undertakings containing protective measures and their recognition in foreign states.
And what? And that's building up to a submission that the undertakings given here are not binding in America.
Well, yeah, that's true as a matter of law because, well, for a number of reasons.
But that's why you're taking
Yes.
us to Roman numeral 4, is it?
Exactly.
Okay.
And my lady, that is developed in the ensuing paragraphs. Paragraph 50 over the page deals with the effectiveness of protective measures, summarising the guidance. He'd already set that out. Protective measures need to be what they say they are, namely protective. And to be protective, they need to be effective. And then there's a citation from Baroness Hale in the Supreme Court in Re E. The clearer the need for protection, the more effective the measures will have to be. And then a point developed by Lord Justice Moylan from Re C, but then reading from just above 53, to like effect, the Supreme Court in Re E pointed out that specific protective measures, as necessary, should be in place before the child is returned. In other judgments, it is said that the courts need to examine in concrete terms what will happen to the subject child if a return is ordered.
Does that mean that there is an emphasis on what is going to happen as a matter of fact as opposed to a technical matter of law?
I think it's both.
Right.
It's going to be our submission that not only is it a question of factually who will have care of the children, but perhaps to borrow an expression from the wardship jurisdiction, it is also a matter of law as to who has custody and control of the children generally, and also in particular who has control over who has the say as to where children should physically live and who should care for them. And then, my lady, all the points raised at 53 on where Mr. Justice Cobb talks about the effectiveness of protective measures, and in particular, in this case, he has a survey of the various different jurisdictions, but in little 5, in many cases, parties may be able to rely on the 1996 Convention, but as I'm sure my lady already knows, as is made clear from the final sentence of subparagraph 5, this is not relevant in the case that Mr. Justice Cobb was dealing with, but is of great relevance to this case. The USA has not ratified the 1996 Hague Convention.
Before we leave this paragraph, subparagraph 4 refers to direct international judicial liaison. There hasn't been any of that in this case, has there?
No, there hasn't.
No contact between Judge Rashid and the English court and the President?
Not that the President has referred to.
Well, if there had been any, then you'd know about it.
I would hope so, my lord, but...
Well, you certainly would.
I'm just being slightly circumspect in my...
Well, I'm not for a moment suggesting that, that now, several years down the line, this becomes interesting. But it might have been at an earlier stage.
Well, my lord, what the President did do is to make pretty standard directions for the sharing of information in general and documentation from the Hague English proceedings to the American courts. There can be no doubt that Judge Rashid knew what the President intended. I don't think anyone is gainsaying that proposition. But without being mealy-mouthed about it, we are not aware of any direct liaison between the President or the International Family
My lord is right, we'd know about it if there had been.
Judge Rashid.
Yep. Okay.
So we would, leaving aside the relevant legal principles, we would suggest that determination of ground one breaks down into three components, and that's the way I propose to structure my submissions. Firstly, an analysis of the judgment of the President and Mr. Mandalia. And my lady will see that, in fact, there were two judges hearing the original application for a summary return.
I mean, on that, taking it very shortly, because it's clear from the judgment under appeal, there's no dispute that the basis of his decision, their decision, was that the children would not go and physically be with the father on return.
Well, we'd say it goes a little bit further than
And
merely
more than that.
physical
Right.
care, which is the point I was making a few moments ago, but not go into the custody,
Right.
which is a slightly wider term, the custody of the father, because the President in his judgment, and that's in paragraph 49, which I think we've all referred to as the key passage, wanted the father to take steps to ensure that as a matter of law, he didn't have the custody and control elements of what we submit the President intended with Mr. Mandalia in their original judgment.
Okay.
And that's really the nub of the problem, if I can cut to the chase.
Well,
Nub,
sorry, just if we're looking at paragraph 49, what it said, I mean, this may be really dancing on a pinhead, Miss, but it was said, we accept that he intends to suspend the current custody order in his favour.
yes, I fully accept that if the children were returned and the matter then returned to the American court, then what the American court does is entirely then a matter for the American court. So to that extent, the President would have been fully aware that the jurisprudence in this area sometimes requires protective measures to be in place for longer than a few days or weeks. But on the other hand, given his keenness and insistence that the matter would be returned to the American court very quickly on the children's return, the arrangements, the legal position he was safeguarding only lasted until that time when the matter could return to the American court.
Sorry, but well, you're going to develop that first point. You say the original judgment you want to...
Yes, perhaps I can just take the court to that paragraph 49 as my Lady Justice King has alighted on it.
Where in this judgment do we see that it was the basis of the this first judgment that the children would not go into the legal custody as well as the physical custody of the father?
Well, page 134 at the top. And this is the passage that I think my lady...
What you mean that shows that it was an important part of the thinking that he would suspect, the father would suspend the current custody order?
Yes.
Right.
So it's just not quite clear from that whether that was something that was going to happen before or after or upon return.
Before return. I can take in due course, my lady, this court to the order that was actually made.
Okay, so original judgment, point 1, 3 components. Second component.
Analysis of what has happened since the decision was made last year. And then depending on the results of that analysis, the stark question whether his subsequent decision not to set aside his original order should stand.
But that turns into the question of was he wrong to conclude that there was not a fundamental change in circumstance?
Yes. So essentially it requires looking at what he in fact did decide and then see what's happened since.
Just so you can signpost this for me, in very precise terms, precisely what do you say is the fundamental change of circumstance?
The fact that because of Judge Rashid's order, the children's petition will not be assured as a matter of law or as a matter of fact. were they to be returned to the United States, because whatever the father undertakes to this court, whatever agreements may be recorded, indeed whatever directions are made, the reality in the States is that the father would have full custody, care and control of his children, and no one can do anything about that.
Could I-
Pending the
sorry.
first...
Sorry to interrupt you, but I'd got halfway through making a helpful, as I thought, note that your assertion is the fundamental change of circumstances is that the children, as a result of the order in the American court, cannot be reassured as a matter of law and fact that when they're returned to the United States, they will not be placed in the father's care before the US court hearing. Is that the...
Custody, care and control of the father, yes. So it's not merely that they would not go and live with him, but that he wouldn't have any control over where they lived. It's all very well, we would submit that the
Yes.
American court gave him the discretion.
Right, so they wouldn't be placed in his care or his control before the emergency hearing.
Yes.
Right, that's
So shortest answer is it's the order. The order is the fundamental change of circumstance.
Exactly. And one has to have some sympathy for the president, because that's not what he wanted to happen.
No.
He wanted the order discharged, it's perfectly clear. Or perhaps I shouldn't use the word discharged, I should use the word suspended, so that the father, until the first hearing in the United States court following the children's arrival, would not have the power, the control, or even the discretion to decide where his children should live. I don't know whether maybe I can...
No, I just wanted the signpost. That's very helpful.
Yes, and I believe that's clear from an examination of the actual orders the President made, as well as the orders that were made in the States by Judge Rashid following his original decision. Can I perhaps then, taking it in my order perhaps rather than my ladies and my lord, go back to the judgment, the original judgment. And what I propose to do is to go through this judgment, then go through the orders of the President, leading up to the return order that was finalised in November last year, then take the court to Judge Rashid's order, and then see where that leaves us with the judgment that was made in July of this year. My lady, there are other important points from the judgment that reinforces my submission that it's important to construe the original judgment in the way that I've submitted, namely that it's not simply the President's determination that the children should physically not go into the care of the father, but that the custody order should be discharged or suspended pending the hearing in the States. And that would require an analysis of what it was that he was finding intolerable. If I can just signpost, the children's case in any rehearing would be to widen their opposition to a summary return under Article 13b, to include a defence on the basis of a grave risk of physical or emotional harm, as well as intolerability. But I accept for the purposes of ground one of the appeal that is not open to them yet, unless this court were to allow the appeal. So the President was looking at it, I have to accept, merely from the perspective of intolerability. And he deals with that in the subsequent paragraphs, looking at paragraph 52, onwards, and the main paragraph is slightly later, but I think 52 puts the position in some context. First of all, he criticises, and it's no part of my submission to defend the mother, he criticises the mother for having generated the difficult decision for the appellants. Then at 53, on that basis, the children's situation will be traumatic, stressful, and upsetting for them to return to the US. This will be acutely so on the day of return itself, and is likely to remain so to a lesser degree for some weeks before medium to long-term arrangements can be made. To a degree, there will be upset and even trauma involved in the repatriation of any children who have been abducted, kept away from their home country. The extent of upset and trauma here is greater because of the likelihood that the mother will be arrested and kept in custody on arrival, with the children, as he then hoped, I add, being moved to foster care. I fully accept the purposes of this appeal, that if the American court, Judge Rashid, had made an order that the children were to go into foster care, that this appeal would have no legs at all. But that's not the situation. But the reason why his default was that the children should go into foster care was precisely to prevent the father having any legal right to care, custody and control. I fully accept that the better option would have been for the mother to return and for the mother to resume care, which is the situation common in a lot of Hague Convention returns, but it was common ground based on expert evidence from an American lawyer, accepted, I think, by all parties, particularly the father, that the likelihood would be that the mother would be arrested, and that is dealt with quite graphically in another part of the President's judgments, that the arrest is likely to take place on the plane. And then the children would be presumably escorted off the plane and would need someone from that very moment to care for them.
Was that going to be, because of course at that hearing you had the upper tribunal judge also.
Yes.
Was the expert evidence that, because obviously your lay client is subject to deportation, she having exhausted all her appeals for asylum, so was the expert evidence that she, if she was deported as opposed to going back to the US under a relocation order, a Hague order, that she would equally be arrested and imprisoned? Or was that not covered in the expert evidence?
I believe that was the expert evidence for the mother, because my clients wouldn't be arrested
No,
themselves.
of course, clearly not. Clearly not.
But they would be left in that predicament.
I'm just thinking, because when you had the upper tribunal judge and the president hearing this situation for these children was, on the face of it, either they would go back under the Hague Convention or they will at some time in the future be deported.
But I think the court was fully aware, as I'm sure this court will be, that in due course my clients, the children's immigration position is of course precarious in this jurisdiction. I'll let Mullen Friend update you on the current position, because I have no direct instructions
Understood.
from the children as to how they might be able to preserve some sort of status here. Plainly, the decisions of the family court are going to have some bearing, but of course won't be decisive, because it's a matter entirely for the
There's a lot of authority, there's a lot of recent authority about that.
Yes.
I'm sure that the family courts don't tread on the toes of the immigration process.
Exactly. But all I can say, I'm trying to help answer the question. I don't have any direct instructions, but my lady will be aware that there are possibilities of making applications on a human rights basis or some other immigration, for some other immigration status, given that the application for asylum by the mother has failed and her appeal has been dismissed.
So really the point of my question was to see whether when you had both immigration and family judges, whether or not the evidence was the same, regardless of whether it was deportation or a Hague order.
I'm not aware of any distinction that was drawn. We don't have the expert evidence, I'm afraid, in the supplementary bundle, because I think it was common ground and accepted by the President that whatever happened, the mother would be arrested. I should make clear that I believe the expert evidence on the basis that she'd be arrested for offences of child abduction.
Understood, yes.
Yes.
Yeah. Thank you, Mr. Holmes.
So, my lady, that dealing with paragraph 53 was the foster care situation. Earlier on, I think my lady had this at the end of paragraph 49, the President's other preferred option that I haven't addressed you about yet was that his hope that the mother would identify a relative or friend. Plainly, that would protect the children against the intolerability of the returning general and the risk of intolerability by being separated from their mother and the risk of intolerability of them being placed in the custody, care and control of the father. The mother has not, as a matter of fact, identified any family member or friend. I'm not sure of the reasons why. As far as my clients, the appellants are concerned, whilst they object to any return, plainly as their advocate, it would place me in difficulties in saying that a return to a family friend, a known family friend, would not be a fundamental change of circumstance if that friend or family was not available. So in other words, the intolerability risk would have been sufficiently protected by the President. My lady, then 54 deals with why, in the President's judgment, going into foster care would not be intolerable. Then paragraph 55, we therefore rely and share the Guardian's analysis that the default plan, including foster care before the medium-term arrangements are settled, is not intolerable. So we invite this court to read that as, well, it's put in a sort of series of double negatives, that it would be intolerable for the children to return to the care of the father. And I think that can be inferred from not only the judgment, but also the orders that were ultimately made. I need to then, in due course, take my lady to the Guardian's own analysis, which was heavily relied upon by the President. As I can do that.
Sorry, Mr. Holmes, before we embark upon that, why do we need to go back into that? Why are we going into matters that lie behind the judgment? It seems completely clear what this judgment means.
Only the part, very much part of the Guardian's thinking was the other main reason for the Guardian's perspective as to why the children should not go directly into the care of the father and should have some other placement, was because she was very concerned that they needed therapeutic intervention before they had their relationship was resumed. But that's the short point. And I need, if it's not going to assist, I need.
But that wasn't the scheme of things, because they weren't going to have therapy between the arrival at the airport and the first court hearing.
Well, the point was that they would have a risk of going into the father's care.
Yes, but that's anyhow. I'm not meaning to stop you going somewhere, but before we have we go deeply into matters that underlie the first decision, we need to understand why we would do such thing. But if that's the point.
Perhaps out of an abundance of caution, can I just take you very briefly to two paragraphs in the supplementary bundle and the final report of the Guardian, which is in the supplementary bundle. This is page.
So it's 203. It starts at 202.
Yes, it's the second report. I would invite the court to read the report in its entirety.
Really?
For the
On ground one?
For the background of the how strong the guardian was formulating the...
Well, which is the paragraph that talks about the therapy point that you just raised with my lord?
Are you talking about the final analysis or the...
Sorry, I'm talking about the final
starting
analysis.
at page
I'm so
270.
sorry, yes, that's where I was struggling to find it.
Thank you. Yeah. Thank you.
The particular passages are at paragraph 31 and paragraph 32.
Thank you. Right.
The guardian refers to the damaging and intolerable for the children to be suddenly placed in their father's care without an adequate transition plan or appropriate support.
Okay. Those are the two paragraphs you want.
Particularly, and then perhaps for the sake of completeness, paragraphs 40 and 41. Just add some colour to how the guardian was considering the position then. And she was summarising the position there. It's made...
And the guardian's ultimate conclusion was that the court should order the return of the children.
Yes, yes, very much. Which is why I'm ultimately led to the reason why I'm conducting the case, or we're conducting the case for the children now, because the guardian did not advocate for their wishes in the outcome that she sought. Paragraph 25 perhaps sets out in detail the therapeutic needs that the guardian thought both children should have. So, my lady, just if I can then put aside the supplementary bundle and take you to the orders which are in the court. I hope I can take this very briefly. Paragraph 93 or 91 in the hard copy is the order, the holding order, as it's been described, made by the President on the handing down of the judgment.
Sorry, what date was that order, please?
This order is the 27th of June. Curiously, it's the day before the judgment hand down, which was the 28th.
I'm just looking at the order, yes?
Yes, well, it's the recitals of paragraph 2 is the,
Yes?
is the relevant one, where the decision was announced. And then the implementation order was made some 5 months later, which appears at 93 in hard copy, 95 electronically.
Date?
On the 5th of November. Of last year, which followed the first attempt of the children to become directly involved, and that was refused. Just preliminary recitals, paragraph 3 refers to what had happened in June, and paragraph 5 setting out what the court was now doing. And then paragraph 8 in terms of implementation. The father has agreed he will, and then little a speaks for itself. And then little b is very tightly worded in my submission. The father agrees he will take appropriate steps as advised by his I think it's Mr. Scanlon is his American lawyer, the American expert. He's certainly an American lawyer. To seek, I have to accept, but to procure that the effective current custody order in his favour, so modified so as not to require to be the children be placed in his care upon their return, pending the proposed hearing US custody proceedings. So
in the event that the US court is unwilling to approve the consent order, the father will take the alternative step advised by Mr. Scanlon. What was that?
I don't think ultimately he was advised to take any
No,
alternatives.
but what was it?
I'm not sure, I'm sorry. Maybe my other learned friends who were present at the, or whose clients were represented at that hearing. I'm not aware, well, certainly didn't play a feature of the set-aside hearings, that there was any alternative step. Because as my lady will have seen, I'm jumping ahead of myself, ultimately the father and the mother did agree that they would approach Judge Rashid to procure that the effective current custody order was so modified.
So the only modification, as was required by 19, the only modification was the father now having permission to place the children with a third party.
Well, with his mother.
Well, it says in the order of third party,
Yes.
it doesn't say mother.
Yes. That wasn't envisaged at that stage.
No, but that was the modification he procured. I mean, I'm not saying rightly or wrongly, I'm not saying how it affects your application, but that was the modification that he didn't get the custody order suspended, he didn't get his consent order approved. All he got, you would say, is the ability to place the children with a third party whilst keeping him in legal control.
Yes. Essentially, he could delegate his care while retaining the custody and control. And may just to emphasise the point that I was making earlier, the steps referred to in both A and B will be taken in advance of the children's return, subject to paragraph 20 below. So that's page hard copy 95. And then paragraph 11 is a recital declaring the court's intention that the order for the return of the children should be implemented in accordance with those agreements. And then the order, paragraph 18, standard declaratory order. And then 19, again, no time, no actual date, but in accordance with the agreements that I've referred the court to. I should, for the sake of completeness, accept that paragraph 20 was included in the case that the mother did not sign or did not otherwise, I suppose, cooperate with the father in the States. The default position then, imposed by the President, was that the children would return regardless. But in the event that didn't arise because the mother, common ground, did cooperate, and an application was made, a consent application was made to the American judge.
Do you say that the reference to being placed in the father's care, for example, in paragraph 9 of this order, it goes wider than physical custody?
Well, to be protective, it must be, because otherwise it's not protective. If the father simply has the right to delegate to some third party while retaining, care to a third party, whether it be I suppose a paid nanny or a relative, but he retains the custody and control, then the protection is wholly inadequate because it's ineffective. The father at any time can exercise whatever rights he sees fit to the children, including seeing them. And worse, if the children's fears are to be allayed. My lady, then the undertakings that the father gave, which were continued by the order made this year, are self-explanatory, but they don't go as far as the President would have wanted, simply because ultimately it would be a decision for the American court rather than the father to decide whether the necessary protection that the President thought necessary would in fact be put in place.
Can we look?
Do you think, are you, sorry, do you say then seek to procure ought to be read as have to procure?
Well, as far as the father is concerned, he can only seek to procure.
Failure to do so, you say, is fatal.
As far as when one is looking at it through the prism of a set-aside application, yes. That's why, you know, it's not part of my submissions about what's happened since November to blame the father, or indeed to accept blame on the mother's part. It's deeply unfortunate that the judge in America was not prepared to do what the president wanted, which was to suspend the father's custody, care and control of these children. And that's the nub of the problem that is faced by this court. Plainly, it's also the nub of the problem faced by the children, were they to return. So perhaps now is an opportune moment to go to the order of Judge Rashid in the supplementary bundle, hard copy 307, electronic 309. So consideration of the father's emergency petition for special relief. That was denied. The mother's motion to quash was a procedural application on her part, which the President did not. I think there was some investigation of the hearing, but he doesn't mention it in his judgment. And then it's the order that the father, a little b, the father shall assume temporary sole, and then the important word here is legal and physical custody. Legal custody, physical care. Whatever, it's clear that that refers to legal rights as well as practical care of all children upon their arrival, pursuant to the earlier American court order, the 5th of October 2022, which gave the father sole custody of the children. Just to fit that in, that was made, we would suggest, as a direct consequence of and reaction to the mother's abduction, not uncommon occurrence. And then subparagraph D over the page, father shall allow the children, and this is perhaps needs some unpicking, the father shall, so that looks like a mandatory order, shall allow the children to be temporarily cared for. It's not giving up his custody, legal or physical, but merely allowing them to be temporarily cared for by a known family member. Whether that requires the children to know the family member, it's perhaps not altogether clear. If he determines, and I invite the court to read into that, if he determines in his absolute discretion that the children are experiencing extreme emotional or mental health issues while in his custody, I hope that this court will accept the view of the President and the professionals that there's no question of whether or if the children would experience, quotes, extreme emotional or mental health issues whilst in his custody. In my submission, they most certainly would.
Well, that might be a point against you. Because that means that if that's right, then well, this court can be assured that as a matter of fact, the father who obeys orders, that's the joint submission, the children will go temporarily to a known family member and not him.
Well, puts a lot of trust in the father. And in my submission, this court can't be satisfied that that would sufficiently protect the children.
But I thought you were
They
saying earlier...
certain-
Yeah, go on. You can't be certain, but your submission earlier was that he is somebody who can be trusted
I don't.
in terms of undertakings and all the rest of it.
I don't think I'm not conceding certain. If I did, then I apologise. I make clear that it is no part of only the children's and therefore my submission that the father could be trusted in this respect to determine that the children were so traumatised. And certainly, if the judge in the state, Judge Rashid, accepted even half of the material that was disclosed from these proceedings, she wouldn't have made that order in the conditional way that it was made.
Well,
don't
I think
think
you're slightly... Anyway, Mr Hames, you are where you are, but your submission from which you don't resile is that we can be assured it is certain that the children will experience extreme emotional or mental health issues whilst in the father's custody.
If they're put in the physical care of the father, yes.
Yep.
And that's accepted by the President. I think it's common ground that he, at any rate, did not want the children and made his order deliberately and very specifically on the basis that the children would not be placed in the care of the father. But I certainly should not be taken as submitting to this court that this court can trust the father to take the necessary steps to protect the children, because of course he denies that he's done anything wrong, and moreover asserts that the reason why they would experience, quotes, extreme emotional or mental health issues is entirely because they've been fed a false narrative.
But that is eliding a lot of different things. You do say he is somebody who respects undertakings. Indeed, the undertakings were accepted and relied upon at all stages. And he is somebody who obeys orders, whatever his position on the substance of the merits behind the scenes. Is that right?
Well, I don't know. He hasn't been tested yet. It's the short answer.
Well, he has complied with all his undertakings so far.
Well, he hasn't had the chance to say. It's an obvious temporal point I can make, because this order hasn't been implemented.
No, but so far as it has been available to him, he has sought to procure the order, etc., etc.
I accept, and I should just clarify that I wasn't criticising, and I don't criticise the father in any way for what happened, and I think I said this, between November and May, when Judge Rashid made the order that she did. But that should not be taken that I unequivocally accept that the father can be trusted to protect the children if they were placed in his custody.
But your point goes wider, ignoring the physical custody point and temporary care point. You say that the effect of this order is to give the father overall control, both legally and physically, of the children.
Which he had in the order, yes, which he had from the order of October 2022.
So in other words, the President made the original relocation order on that basis, knowing that that was the case.
But
when the father had that control, and we don't know how it works with parental responsibility and working together with foster parents and so on. So we don't know what level of control the father would have had if the children had gone into foster care.
Not if they had gone into foster care. The President accepted that whatever the American law was, that the children going into foster care would be sufficient. And no doubt, and I don't have any evidence for this, but no doubt if the children were in foster care, there would be some steps taken to protect the children from being removed from foster care unilaterally without a further order from the American court. Otherwise, there'd be no point in insisting that they go into foster care, my lady. Sorry, that perhaps sounded a bit too flippant, but that must be the serious point. There's a world of difference, not only in the care, but also in the legal position of children in foster care on the one hand, and children in the custody care of a parent who simply delegates the care to a known family member. And my lady can be reasonably satisfied with that because the President's return order was made very much on the basis that the father would seek to procure that change to the legal position put in place by the order of October 2022. Otherwise, the President needn't have gone to that trouble. But he did go to that trouble because he accepted that the children needed protecting from what would otherwise be an intolerable position under Article 13B.
As to the understanding following the American order as to when the matter would next be before that court, the father's agreement in November was to try and get a hearing 7 to 14 days. And the judge's order, it's the last paragraph of her order at page 309, 311, was that once the children are in father's physical custody, his lawyer notify the court and an emergency hearing will be scheduled for the children to be present at the hearing. So that's the information that this court had about timescales. All the information as far as I'm aware.
Yes,
Yeah, right.
I thought there was no, I don't think there was any other evidence about how quickly.
No. Well, the judge characterised it as an emergency hearing, so one presumes
Yes,
she would give it some priority.
yes.
I mean, just picking up on my Lord's point, page 307, we can see it's an emergency petition filed on the 28th of February.
Yes,
So the father has the November order, issues his emergency petition in February, and it's heard in May the 6th.
yes.
Do we have a transcript, or is there any reasons or judgment behind the order of Judge Rashid?
We do, but I don't think it's in the supplementary.
No, we may not need it, but it might be interesting to. Well, that's probably not the right test, but I think it would be helpful
Yes.
to see the reasons. And also, if I look at picking up again on my Lord's spot in paragraph 5, if you look at the narrative of this order and the logic internally, it does look as if there is anticipated at least a period when the children are in the physical custody of the children, because if you look at paragraph, if once children are in father's physical custody, and if you look at para D on paragraph 3, he can only determine that the children are experiencing extreme emotional or mental health issues whilst in his custody when the children are in his custody.
Yeah.
So the chronology appears to be children go straight to father, legal custody, but also physical custody. If whilst in his physical custody, he determines that they are experiencing extreme emotional and mental health issues, then he can permit temporary care elsewhere.
Yes, but exactly only once they were in his custody.
Yeah.
But that would fit with the overall scheme, because the court wasn't in any way restricting his custody.
How are we to see the record of the hearing?
It was before the President.
And is there a short note of reasons of judgment? Or?
I think well, I know that in evidence, from recollection, the father, possibly the mother as well, exhibited that to their statements.
Great.
Which
Well,
I
if we
don't
could
think
see
have that, I'm sure that some
Thank you very
junior
much.
made that available.
Thank you. Take advice, agree between yourselves whether we need to see the emergency petition for special relief, the answer and motion to quash, and then it looks as if there's a recorded conference with counsel. That's what we're looking for, and then a note of reasons or judgment.
Yes, well, I can't remember whether I don't think there was a transcript of the conference, unless it was simply the hearing that's been referred to there.
Yeah, I'm sure that's right.
So, but I think there is somewhere a note of judgment
Good.
that was before.
Well, if we could have that as soon as possible, that would be
Yes.
helpful. Thank you.
I just turn my
And my lord confirms, I mean, email to our clerks, at least one of our clerks will,
Yes.
will do the job.
Thank you very much. Yes, just building on the point that my lady's just made, although the father undertook to this court, or to the English court, that he would not attend at the airport, my lady will note from this order that there is no such inhibition from him attending the airport.
I think, speaking for myself, your core point is that the fundamental condition in the President's return order was that the children would not go into the care of the father in any shape or form unless and until the American court so ordered, at a hearing to be convened after their return. Your interpretation of this order, which I quite understand, is that the American judge's fundamental position was that the children should go into their father's care unless there was, in his view, a reason not to do so.
Yes.
And so what we're left with then is a consideration of what the father would in fact do, faced with this judicial disagreement.
Well,
Is that one way of putting your appeal?
it's what the father could do as well as what he would do. Because if he could do, if he could retain care,
Well,
that
clearly we only get to would if he could. On the face of it, he could.
yes, once they're in his care. Sorry, does that deal with my lord's point?
Yeah.
Yes. The person selected by the father, you'll know from the children's statement, or Miss Hanson's statements and from the skeletons, that the children have very little knowledge or indeed information of their paternal grandmother, who is the only person who the father has mentioned. Bearing in mind the children haven't seen her now for well over 4 years, it's not surprising they have little memory of her. For what it's worth, they believe that she is a Spanish speaker and doesn't speak very much English at all. So even if he were to place the children with her, it would hardly be child-centric. Of course, that's not the issue. It's whether it would be outside what the President intended. It's very difficult to construe the President's original judgment as, while accepting that foster care, professional foster care, that it would not be intolerable. It's our suggestion that if he'd been presented with a non-English speaking relative of the father, who is likely, as we've said in our skeleton, to kowtow to whatever the father wanted, that does not protect the children against the intolerable position.
Well, when we go back to the November order, at paragraph 9, recorded that the father had agreed that if the mother was arrested, the children should not be placed in his care pending the hearing, but placed into foster care in the absence of any other suitable third party being available. So I think the President did have in mind the possibility that it may not be foster care. And what we do know from the first-tier tribunal hearing is that the mother's evidence was that she had a good relationship with the father's family and was on good terms with them until all this happened.
I can only make submissions on what the children's recollection of the father's family was, as expressed to their guardian and now next friend. The judgment doesn't refer to any family of the father. The judgment refers specifically to the mother nominating someone who she knows, no doubt on the basis that the children were more likely to know someone who she knows rather than someone than the father, given that they hadn't had any contact at all with the father for now 4 years. But I accept that the undertaking is not expressed in the same way as the judgment on that submission.
Just looking again at the American order, this may all become crystal clear when we see the notes of the hearing or the judgment. But if we look at E and F, if the children, they can contact the mother without restriction using their own cell phones, but if they don't have one, then use the father's. And likewise in reverse. So there is this theme of physical proximity.
Yes. If the mother is in custody, that may present a practical issue. That's the basis of the...
But in fact,
President.
sorry to speak over you, Mr. Holmes, the scheme of the American order is not contingent upon whether the mother is arrested. The American judge's expectation is that even if the mother was at liberty, having brought the children back, the children would still be placed with the father.
Yes.
And so, although the parties may have been operating on the basis that the mother will be arrested, the American judge did not even leave open the possibility of the children remaining with their mother if she was able to look after them.
Yes, I was making that previous submission just in respect of the contact provisions that my lady was referring to.
But it reinforces, my Lord's point reinforces that this was all options on the table in terms of where the mother was.
Yes.
Yes, but no option at all of the children remaining in the care of their mother.
Whether or not she was arrested.
Regardless. Regardless whether she was arrested on the tarmac, which is what the President envisaged. Underlining the point that the American Judge Rashid was paying little regard to the President's concerns about the intolerable position that the children would face if they were placed.
I'm bound to say this point only struck me when my lady raised the question of phone calls, because I don't imagine that if the mother was in custody, phone calls would be at all easy.
Exactly, ma'am. That was the point I was endeavouring to make.
And a 7 p.m. fixture.
Yes. From recollection, I can't recall, but we'll see in due course whether Judge Rashid made any regard to the prospect of the mother being in custody or otherwise, but we'll see in due course. Mm-hmm. If I may then leave this order and take you to the judgment under appeal from the main bundle.
Well, what and this is entirely speaking for myself, was looking for in this judgment was where the judge grappled with this order in his analysis.
Yes.
Whether the President dealt with this order.
He deals with it. Take you to page 162 in the core bundle, which is the judgment, and it's paragraph. He sets it out in narrative form in some of the preceding paragraphs to the one I'm going to take, my lady to.
But I'm looking at discussion and conclusion.
Yes, paragraphs 28 to
Yes.
29. He analyses his own judgment at 29. And there is reference there halfway down to him having read paragraph 8A and 8B.
Of his own November order.
Yes.
I mean, Mr. Gupta will be addressing us on this, but I don't see where there's a lot about the structure remaining the same, i.e. go to America, get a quick hearing.
Yes.
That all remains the same, the basic structure. But where does he grapple with paragraphs 3?
Well, the short answer is that in this section, he doesn't.
Right, so it's
But he
elsewhere.
refers, as I was saying earlier, he sets out in a narrative form. So paragraph 13 of 158H.
Paragraph 12.
Sorry, yes, paragraph 12. And then paragraph 13.
I'm bound to say, Mr. Hames, I mean, this may be a point that that assists you, that I hadn't previously focused on the fact that the American order appears to have as its foundation that the children will not be with their mother, even if she's available. I'm repeating the point I made before, but
Yes.
it doesn't seem that the President, the thought maybe occurred to the President, maybe because everybody assumed she wasn't going to be available.
The President knew in June 2024 that the American court order of October 2022 had given sole custody to the father. And so
As you say, not an uncommon
exactly.
state of affairs.
So if that, hence the reason why he wanted, put it that way, wanted the father to take some action in the American court to, at the very least, suspend that order. The American court didn't do that. The American court essentially reinforced that order, save for the proviso that we've just been looking at.
Yes, I think that the point that is occurring to me is that the silence about the American judge's assumption that the children would be removed from their mother regardless shouldn't lead us to overlook the fact that that appears, subject to anything that you give us from the actual proceeding, to have been her approach. And that also may shed some light upon what she meant by the parts of the order that are expressed, namely what she was expecting of the father. But one thing I think seem to have established is she was not prepared to accept that the mother should keep the children.
On any view, that's. But she'd already essentially made that decision in October 2022.
Yeah. And so that at a number of levels, I imagine you would say the philosophy, maybe a perfectly good one, of the American court was at odds with the philosophy of the English court's approach.
Perhaps, yes. I mean, on the face of it, the President wanted to, or one might say that the President wanted to produce a child-centric solution, whereas the American court was still determined that a child abductor would not be given custody of the children. And to that extent, that of course is a very different and strikingly different between the American court and this court, as illustrated not only this case, but perhaps in other cases too. I think just going back, I think it was to my lady's question, that there's paragraph 12, 158G.
Well, I've read it. I understand that it's recited in the narrative.
That's it,
No,
yes.
There is. So it's paragraph 31 is the crux of it, of the judgment.
Well, the discussion, yes. But that's as much an analysis of his judgment. And then he simply refers to the changes being to the detail. But the structure remains the same. Which was not what he intended. He intended to change the structure. I go back to the reason for that, not so much that it was in the best interest of the children, because it was required to protect them from the Article 13b intolerability. Before I overlook a very separate chronological point, just so the court is clear, paragraph 13, in fact, it was the father who brought the proceedings back to this court, because he wanted to vary the order. We expressed the somewhat ironic view that the father himself was the one who, in a sense, invited the court to reopen matters in general and reconsider in particular the implementation of the order, which ultimately the President was prepared to do. But there isn't any further analysis in this, the subsequent judgment, of whether or not the protective scheme, using that term in the widest sense, had been so fundamentally changed by the decisions of the American judge that he should set aside his order because of that fundamental change.
Just pausing as you go there, and this is the crux of it, so I don't want to interrupt, but looking at paragraph 14, it's right, is it, that the American order having been made, the father wanted it to be reflected and implemented?
Yes.
Yeah.
Hence, he brought it back. I mean, so I was perhaps light on my criticism of the father, because the father very properly brought the matter back to the English court. And then the President, my lady will be aware of what happened from the skeletons. The President then relisted it and gave directions for the children's former solicitor to be notified.
My understanding, Mr. Hames, looking as my lady, the Lady Chief Justice has pointed us to paragraph 14, is that when the father sought to vary the terms of the order to fit in with the orders made in America and to provide for the repatriation of the children in accordance with that new revised regime, we can tell from what the President said in the discussion, what was being asked was so that the children could be repatriated and placed with the grandmother. It wasn't that the father was coming back to the court and going, aha, I now have an order that says I'm going to have immediate physical custody, and so that's the order I now want. He was still, as I understand it, on the application to bring the matter before the court, was still saying, I accept I won't have physical custody, the children will go to the grandmother.
Well, he was accepting that the American court had not done what he wanted to do.
No, that wasn't my question.
No.
Sorry, I misunderstood.
No.
The father came back to this court after the American order was made, and he was saying, What's now happened is the consent order wasn't made. Please make an order for the repatriation of my children so that instead of them going into foster care, they will go to my mother, the paternal grandmother.
Yes, I mean,
He
that-
was
that's what
not saying, I now have an order that says the children come straight into my care and that's what I want you to order, President.
No, he did that.
No.
I think if
sorry.
it's a bit, it's the way in which it's an extemporary judgment, it's the way it's expressed, but I think really what he was asking, he was seeking to vary the terms of this order to get around the orders that had been made in the American
Exactly.
court, or to accommodate
Yes.
the orders that had been made in the American court.
Because he was accepting that, whatever it is, D, C, D of the order, namely the children would be suffering if they went into his care, and he was accepting that, and he was saying that the children would be going to his mother.
I think that's right, but he was also, plainly accepting that he hadn't succeeded in doing what the president wanted him to do, and that's why.
Yeah, understood. Okay. So I interrupted you when you were just building up to your third submission, the big one. I think wrong not to find a fundamental change of circumstance. The
Well,
fundamental.
that's my overarching submission, but my point was going to be that there is no real analysis of the impact of the refusal of the court in America to put in place the protective regime that the president wanted, as clearly expressed in his judgment and his orders, which we've characterised as being that the children would not be in the physical or legal custody, care and control of the father. And he failed in that, not because he hadn't tried, but because of the decisions of the American court.
And would you accept that if the American court had simply made an order reflecting the arrangements that had been in the English court's mind, we wouldn't be here?
Yes. The appeal remedies of the children have been exhausted because Lord Justice Moylan last year.
Well, I
refused their
didn't
applications to appeal
mean
the
for
internal.
procedural reasons, but simply there would be nothing to argue about.
Exactly. But I suppose the point I was endeavouring to make was that there was a certain irony that it was the father himself who recognised that there had been a change of circumstances. We would characterise it as fundamental. That was the main point I was trying to make. But of course, if the American court had done what the president wanted to happen, we wouldn't be here.
But what the father was saying is what the president said in paragraph 31. The basis not fundamentally changed, said the father. The change has been to the detail of the arrangement. The basic structure remains in place. The children would not go into the care of the father, but instead of going into the care of foster carers, they'd go into the care of the paternal grandmother.
But that's not pursuant to any legal order, that's simply pursuant to his agreement, his assertion, which is not what the president wanted in our submission. Otherwise, the president wouldn't have put the father to the trouble of discharging or suspending the custody order. The president, in his return order, could simply have said, can you come up with someone else who the children can live with? I'm not going to require you to discharge anything. That'll do. I'm perhaps paraphrasing in a slightly sloppy way, but that is effectively what the president did not. It's not what he did do, because he was aware that protective measures had to be effective and enforceable, and simply leaving it to the father was not sufficient. We say he fell into error in his July judgment by not recognising that there was a fundamental change in what would happen when if the children returned. And that is, I accept, the gravamen of our submission.
So is that the set aside? I'm conscious that we have
Yes,
detained you along the way. Thank you for dealing so patiently with our questions. And with an eye on the clock, just moving to the what if on the hypothetical that it falls to us to redetermine.
Yes, and we've set it up in some detail in the skeleton.
You have, and we've read that.
Of course, the children haven't filed a full answer and they haven't, in terms, set out any evidence in support of a defence. The evidence thus far from Nina Hansen, ex-friend in these proceedings, children's guardian below, has really dealt with the evidence for being joined, separate to their guardian, being represented separately to their guardian, and also in support of the set-aside. But nonetheless, we would invite this court to deal with the rehearing if it can.
Could I, before we consider this, could we maybe just make a short list of what the possible options would be if the appeal were allowed? I mean, it occurs to me that one thing that could be done is to set aside the return order, and that is what you are first arguing for. Another possibility would be to suspend the return order, to give the American court the further opportunity to, putting this bluntly, fall into line. Another possibility would be to set aside the return order and remit to the family court, or the High Court, in fact, to redetermine the Hague summons. Another possibility would be for this court simply to dismiss the Hague summons, which I think is the one which you were alighting on a moment ago.
Yes.
Are those the differential possibilities, broadly speaking?
I can't think of any others. I'm not sure how the second one would work, which is the idea of suspending a return. I suppose this court could adjourn the appeal, or I'm trying to see how the court could suspend the order without setting it aside.
Yeah, it would be some sort of adjournment, potentially.
Yes. That was all. Of course, if that was the, and I'm just addressing this very narrow point, if that was the view of the court, the other way to deal with it would be to say so in the judgment and remit it for a rehearing, which is not what the children ideally would want, and leave it to the rehearing judge to decide what protective measures or what steps could be taken to effectively ask the American court to think again, which is, I think, what my lord was driving at. It's not something that we're instructed to advocate.
No, I think my lord's quite rightly just floating all possible options and giving you the opportunity to comment. One could adjourn with reasons, presumably.
Yes, I think that's a possibility. I don't think anyone's particularly advocating that, as far as I'm aware. Certainly, it's not foreshadowed in the skeleton arguments.
No.
The child's objections must get through the gateway stage. I hope I can take this quite quickly,
yes, please.
my lady. Then the only issue then will be the discretion. Plainly, the children are much older than when they were first seen by the Kafka's guardian in September 2023. They're older, 15 months older since the president actually made his decision. Their wishes and feelings have been consistent throughout that period, and they have been expressed in a very forceful way, as I indicated earlier in my earlier submissions, which I don't need to repeat. Our simple submission is that the children's wishes are for those reasons, are outweighing of all the other countervailing factors, particularly the convention factors, particularly those factors based on the mother's conduct, which is not something that we would submit should be brought home to the children.
In the exercise of the discretionary aspect, when you get there, would the judge, considering the exercise of his or her discretion, take into account the precariousness of their immigration status? In other words, the children don't want to go back. They feel very strongly about it. Everyone knows that. But in deciding ultimately whether they have to go back, would the judge take into account, well, they may well have to go anyway because they're likely to be deported?
Plainly, the discretion is at large, and it's very difficult to exclude entirely any factor. But they haven't been deported. thus far, as far as I'm aware, and I don't have specific instructions on this, no attempt has been made to take any preliminary action with a view to deportation. As I've already alluded to, there's the possibility of further applications being made to recognise their immigration status. So whilst I accept that it's something to be weighed into the balance, I'd invite this court or any other court rehearing the case not to place undue weight on that factor, and certainly not sufficient countervailing weight as against the very powerful objections and indeed refusal of the children. Besides, they've been here now for 3 years, to paraphrase Baroness Hale. You know, what are they supposed to do while the adults argue? They've gone on with their lives. And my lady will be aware of all those other factors. In any discretionary balance, of course, there are factors that go in favour of the return order. I can't try and persuade this court of any otherwise. But the court has already made sterling efforts to try and produce a safe and protective regime in the States that sadly has not been possible, which is links into the Article 13b case, even if one restricts it to the intolerability point that the mother raised at the first hearing. The children would wish to expand on the Article 13b to include grave risk of physical or emotional harm due to the possibility that they are right and that the father has done the things that they say. My lady, for these purposes, in my submission, all I need to do, or we need to do, is to satisfy the rehearing court that the possibility that their allegations may be true, put at their highest, this court cannot discount them without then going on to consider protective measures. And in view of, we rely on the independent social worker who the mother instructed in the asylum case, as well as what the children have said to the guardian, the Kafkas guardian, as well as to their solicitor, that for their part they strongly believe and they repeat, and for them it is the reality of their lives with the father that they did suffer from the abuse that they say they experienced. So the point I made earlier, I repeat here, the court doesn't have to make findings or even go into a forensic analysis, as the first tier tribunal did, of what happened into the States. It's simply sufficient for a Hague court to be satisfied that the possibility cannot be discounted. And I have in mind what Lady Justice Black said in the Lithuanian case, which is referred to in Lord Justice Moylan's judgment, I think in Re A. Because if the court cannot discount the possibility of the children's allegations being true, then it must consider protective measures. And I can take this very shortly. If the court has set aside the order, it almost follows, as night follows day, that the court would not be satisfied that any protection could be put in place to protect the children against that risk.
But you rely on this aspect of the hearing on your very full written skeleton argument and the points there. And
yes, unless I need to develop at this stage. I haven't taken my ladies to the authorities on particularly the permissibility in limited circumstances of the court not getting as far as protective measures, but they are referred to at some length in the skeleton. I'm very much aware of the time, but I can do that if it would assist.
my lord has a question.
Just one question, if I may. You were referring to whether or not the validity of allegations can be confidently discounted and so forth. What difference does it make that those allegations have, under whatever form of system, been considered both in the United States and also in the tribunal system here. Are you saying that that normal process just continues in any event, regardless of the fact that various courts have considered them and not found them reliable?
It's part of the background and the background only.
Yes, but I mean, would you accept that that in most of the cases when one's talking about taking things at their highest, or confidence in discounting reliability and so forth, that those cases are against normally a vanilla background where nobody has actually looked into the allegations, but that where one has a finding of a convention court, and indeed of a domestic tribunal about those matters, doesn't one not have to take a rather different approach?
Well, my lord's entitled to take a different approach. The Hague Court has got to look at Article 13b, and my lord will know from the skeleton that we take issue with as much as anything, the process that the American court, particularly, but also the American system, and I can go into all that if it would assist. A lot of it is, if I may respectfully say so, sort of pretty sort of standard criticism when one compares it with the way that the English courts do that, and I can do no better than refer to my lord's own judgment about how these interviews should be arranged. Of course, like I say, I can't submit that this court should ignore it, but I do submit that this court is not bound by that. And looking at the particular risk for these particular children in the light of all of the evidence, some of which has only come to light since certainly the American court decision, but also the first-tier tribunal decision, that this court, nonetheless, taking that focus, can not confidently discount the allegations.
Understood.
Not being true.
Thank you. Thank you very much indeed, Mr. Hames. We don't need any further assistance at this stage, but Miss Burley, we see you in the second row. This court is always very pleased to see junior counsel. Do you follow? Is there anything you'd like to add?
I do.
Thank you very much. All right, Mr. Gratian.
My lady and my lord, we, on behalf of the mother, support, as you will have seen from our skeleton argument, the children's appeal, essentially for the reasons that they give in support of the ground. We also support the proposed outcome on behalf of the children of a rehearing of the substantive application, if that's the point that we get to. I wanted, if I may, just to try and provide a little assistance in relation to the aspect of the structure around return that involved the children staying with their mother if they weren't arrested, and how that, or if the mother wasn't arrested, forgive me, how that was dealt with in the US. You will have shortly, if you don't have it already, the transcript of the hearing that took place before Judge Rashid, which forms a part of this, but I wanted...
Is the transcript very long?
Yes.
So next request would be very helpful if you could all agree which particular passages we need to read over the short adjournment for those of us who have a chance. That will be very helpful. Thank you.
And
yes.
I will, I suppose, putting in this way may be helpful or unhelpful when you get to your reading, but I will try to take it in a general sense.
Thank you.
As we will undertake that task, and you can read the specific parts. But I wanted to start in this regard, if I may, within the core appeal bundle and the order that was made by the President in November, which begins at 93, electronic page 95, in that bundle. I won't take long doing this because you've already had some...
Sorry, my fault, I wasn't listening. Page 95 of the supplementary bundle.
Yes,
Yes,
that
thank
is
you.
the first page of that
Thank you.
order.
Yes.
You've looked with Mr. Hames at paragraph 8 of it at electronic page 97, which sets out what the father had agreed in terms of the structure of the return. And at 8b, particularly, that he would take the steps as advised by Mr. Scanlon. Just for clarity, although I don't think it's important. The two steps were modification or an application for special relief. So the first step, as set out there, was modification of the custody order, and then where it says the father will take the alternative step advised, that was an application for special relief, which is what the father in the end did. But it's necessary in our submission, just to touch upon this, to read 8 alongside the proposed consent order, which is within the bundle at 104. So it's appended to the end of the President's order.
Yes.
And particularly paragraph 1, which sets out the father's agreement to temporary physical custody of the children going to the mother, and that being discharged until the first listed date of the first emergency hearing. So that was, on this structure, the primary mechanism we would submit as to how this return was going to be effected. And then paragraph 4, which is nonetheless significant, bearing in mind what happened, we say, is the alternative. If the mother's arrested, then foster care. Now, you don't, within the supplemental bundle, have these documents, but the mother, within her evidence for the hearing before the President of her set-aside application, filed a statement that addressed the hearing before Judge Rashid. And it was the mother's evidence in relation to that hearing, reliant upon the transcript that you will receive, or have received, that during the course of that hearing, the father's position through his attorney appeared to change, and he was not expressing himself to be in agreement with the mother having custody of the children, whether on a temporary basis or otherwise. In addition to...
That may have influenced the order that we see at the end then.
Yes, and...
Well, you don't know whether the father was picking up signals from the court or the court were picking up signals from the father.
Well,
I mean, we may see when we...
yes.
And so far as I can see, nothing's yet landed.
What I would suggest is apparent from the transcript is that there was a little of both of what my lord has just suggested. The mother had also filed a statement from her attorney, Miss Ingham, which was to the same effect, that a different position was being advanced on behalf of the father before the American court in relation to the terms of that agreement than it appeared he had agreed to, as appended to the order from November. The reason I'm referring to the evidence, in addition to the transcript, is just to make the point that this change from the return being envisaged to be in the custody of the mother and then remaining with her if at all possible, to what we see in the American order, where there is no reference at all to the mother having custody, indeed the opposite, the father retaining custody, was an issue on the evidence before the President for the purposes of the set-aside application. As I said, dealing with it generally, what one sees from the transcript, and we will point
Well,
out...
it must be possible to get us the transcript. Where has it been sent?
I do not at the moment know, I'm afraid. We, I think, have it separated out now. It was part of a very long bundle of American proceedings. I think someone behind me is undertaking the task of separating the documents, so it can be sent without you having to have everything.
If any of this is, well, no, that's fine. All right. Well, for whatever reason, it hasn't arrived. Carry on. Yes.
There are perhaps two fundamental aspects of what transpired before Judge Rashid that impacted upon the arrangements that the President had put in place for return, we would submit. The first was that Judge Rashid considered that the parents agreeing to a return into foster care and so engaging children or child's welfare services in the US in that way was not possible and not something that she, the judge, could sanction. So that took, for the purposes of...
What, as a matter of jurisdiction or procedure or what?
I think, on my interpretation of what's said in the transcript, as a matter of jurisdiction.
Right.
But it is wrapped up in a lot of considerations in relation to, and these are not necessarily unexpected, but why parents who are present or who have family who could step in are prevailing upon state services to look after
welfare
their children.
and principle.
Yes. Ultimately, I think it came down to jurisdiction, but there are a number of things
Merits
that are
as
said
well. Okay.
of this. And second, that the judge was not, and this seems to follow on from submissions made on behalf of the father, going to order that the mother have custody at all. And so in the course of that hearing, the two mechanisms that were advanced or were accepted within the 1980 Hague Convention proceedings here for a return of the children that would not be intolerable, one, a return where they stay with their mother, two, a return into foster care, were taken off the table. And we have then, as a result, the order that provides for, in the first instance, as you've seen and looked at with Mr. Hames, custody with the father, and only if, and it must be right, as my lady said in discussion with Mr. Hames, that this involves the children going to the father first for him to reach this judgment, only if he decides that they are so emotionally distressed that alternative care is required, he can then place them in the care of someone else. And the consequence of it being arranged in that way is set out, albeit with reference to the father's existing custody order, during the course of the hearing in discussions between the attorneys who appeared on behalf of the parents there and the judge, which is that the father could simply turn up at the airport with his custody order and take the children into his care. But in our submission, bearing in mind the approach that is taken both within the judgment as then condensed into the order, what happened in America removed the protective framework that was placed around the children in order to enable them to return in a way that wasn't intolerable for them. And that was, we submit, clearly a fundamental change of circumstances that swept away, really, the basis upon which the President ordered return in November of 2024, because that return was based upon what he accepted the father would do, which was to lodge the consent agreement that was appended to the order, which consent agreement envisaged return in those two particular ways, neither of which now are possible on the basis of Judge Rashid's decision.
Did the President have the notes of the hearing in America before him?
Yes.
All of that was in evidence, was
Yes.
it?
There was a separate bundle of US proceedings, which included the transcript of the hearing and, of course, the order that Judge Rashid made, which was the focus of the arguments that were advanced
I
there.
think it would be useful, not suggesting they should all be sent, but it would be useful if we at least had an index to the bundle that was placed before the President, so that we could see what we
Certainly,
haven't so far seen and decide whether we need to see it or not.
of course. I'm sure that can be done. You have the other submissions that we've made within the skeleton argument, which, as I said when I began, really support and endorse the submissions made on behalf of the children. I wanted to add that because, of course, Mr. Hames was on his feet whilst the US hearing was being discussed, and I had the advantage then of being able to look back over some of the older documents.
Of course, I understand.
And the transcript. Unless there was anything specific that it would be helpful on behalf of the mother for us to address, I wasn't going to make any further submissions, whether in support of the appeal on set-aside or in relation to the rehearing of the Hague Convention case, because our case in that regard is that the children, or it has been stated firmly on behalf of the children, what their objections are and the intolerability that they say would arise for them in relation to return, and we support those arguments.
Thank you very much. Thank you, Mr. Gratian. Ms. Kumar, anything you would like to add or follow with?
My ladies, my lord, no.
No, thank you very much. Mr. Gupta, it occurs to me that we are doing well on time, and
Yes.
there is a world in which we have a look at the transcript before we have the benefit of your submissions.
Yes.
Does that strike you as a sensible suggestion?
Well, I did toy with the idea of suggesting that, Your Ladyship.
Just ask my lady.
Yes, I agree.
Do you agree with that? Do you agree with that?
They have arrived. There's 70-odd pages of them.
Thank you. And
And we need to find the index as well.
off the top of your head, any particular passages or pages that we should concentrate on, or we're going to do
I need to
quick,
look at
a
it.
speed read?
I'm afraid I need to look at it as well.
Is my assumption that we are doing okay for time?
Yes. I was going to say
a
I was
fair
going to
one.
finish by lunchtime subject to any
Well,
judicial
in that case,
questions.
why don't we resume at 2?
Yes.
Is that okay, all right with you? And then we'll have the benefit of your submissions, to which we're much looking forward, and any replies from Mr. Gratian, Mr. Hames. Thank you. Have a think as well between all council, having heard the exchanges today, whether or not there are any other bits of material that we could usefully see. At the moment, we are expecting the transcript, an index of the bundles before the President, and you are then going to think further about highlighting any passages in particular for us, and whether or not more generally we need any other material that has been before either the American courts or the courts below.
Yes.
Thank you very much
Thank you.
for your assistance so far. 2 o'clock.